Come back to the channel Rahul Study. In this video, we just cover the case, namely Surajmani, Stella Kujur versus Durga Charan Hansdah. Citation of this case is All India Report 2001, Supreme Court 93-8, and the third edition of the book published in 2001, Supreme Court page number 13. This case was of 2001. Justice R.P. Sethi. This case covers the who is into trying to the differentiate the who is Hindu. Actually, not a who is Hindu, but who can be a Hindu. Okay. Uh, who is a Hindu for the purposes of applicability of Hindu Marriage Act 1955. For Hindu, there is the Hindu Marriage Act 1955 is a question of law to be determined in this appeal. Okay, this case all about, guys. Okay, all about who is Hindu. The Marriage Act for the Hindu and published adopted in 1955. Okay, the third section 2 of the act specifies the person who to whom the act is applicable. Section 2 of the Hindu Marriage Act regarding the person to whom the act is applicable, that is the Act of Marriage Act for whom is applicable. Clause 2 of Clause 2 Section 2, there are three clauses of Section 2, A, B and C, and subsection 1 of the Section 2 make the applicable to a person who is a Hindu by religion in any of its form or developments, including a Virashaiva, a Lingayat, or a flower of Brahma, Pratna, or Arya Samaj, or to a person who is Buddhist, Jain, Sikh by religion, include Hindus in the family of Hindus. It is also applicable to any other person domiciled in territory of India who is not a Muslim, not a Christian, not a Parsi, or not a Jew by religion is considered in the Hindu. The applicability of the act is therefore comprehensive and applicable to all persons domiciled in territory of India who are not Muslim, Christian, Parsis, and Jew by religion. So, this Hindu Marriage Act applicable to whom who is not Muslim, not Christian, not Parsi, not Jew by religion, and also to whom Buddhist, Jain, Sikhs by religion, and also developments including Vaishya, a Lingayat, a floor of Burma, Pratna, or Arya Samaj. All these expression covers the Hindu Marriage Act under the Hindu Marriage Act. Okay. Fourth, the term Hindu has not been defined either under the Act or the Indian Succession Act or any other enactment of the legislature. As far back as in 1903, the Privy Council Bhagwan Kaur versus Justice Bose observed. In this case, there that observed that there is no a defined the term Hindu. Only only bifurcation of Hindu, who is Hindu, not exact meaning of Hindu elsewhere. We shall not attempt here to lay down a general definition of what is meant by the term Hindu, to make it accurate and at the same time sufficiently comprehensive as well as distinctive is extremely difficult. The Hindu religion is marvelously Catholic and elastic. Okay, its theology is marked by eclecticism and tolerance. Eclecticism means the very vast domain of the Hindu, and tolerance and almost ultimated freedom of private worship. Its social code is much more significant, stringent, not significant, much more stringent, but amongst its different castes and sections, exhibits wide diversity of practice. No trend is more marked of Hindu society in general than its horror of using the meat of cow. Yet the Chamars who profess Hinduism but who eat beef and flesh of dead animals are, however, low is a scale included within its pale. It is easier to say who are not Hindus, and practically the separation of Hindus from non Hindus is not a matter of so much difficulty. The people know the difference well and can easily tell who are Hindu and why are not. Okay. The act is therefore applicable to first all Hindus, including a Vaishyava, a Lingayat, a Brahma, a Pratna Samajist, and an Aryan Samajist. Buddhist, Jainist, Sikhs, all over this expression. In this appeal, the parties are admittedly tribals. The appellant being an the who is appellant here? The appellant Surajmani, Stella, Kujur, and the respondent is Durga, Charan, Hansdah. The appellant being an Oran, and the respondent a Santhal. The Jati, there is a religious, spiritual, the Oran or a Santhal. In the absence of the notification order under the Article 342 of the Indian Constitution, they are deemed to be Hindu. वो मान लिए जाते हैं कि वी आर हिंदू. Okay, related to the tribal. Okay, even if a notification is used under the constitution, the act can be applied to the scheduled tribes as well as by further notification in the terms of subsection 2 of the subsection 2 of the act. Subsection 2 of section 2 of the act. It is not disputed before us that in the constitution scheduled tribe order 1950 as amended by the scheduled caste and the scheduled tribes order amended the act 63 of 1956, 108 of 1966, 1976, 18 of 1987, and 15 of 1990. Both the tribes on which the party belong are specified in Part 12. It is considered even by the appellant that the party to the petitions are two tribals who otherwise profess Hinduism but their marriage being out of purview of Hindu Marriage Act 1955. In light of section 2 subsection 2 of the act are thus governed only by their Santhal custom and usages. Okay, the appellant has however relied upon and the alleged custom, the tribe which mandates monogamy as a rule. It is submitted that as a respondent has solemnized a second marriage during the subsistence of first marriage, with the appellant the second marriage being void. The respondent is liable for the prosecuted for the offence punishable under 494 of the Indian Penal Code related to adultery, I guess. No custom, the punishment would be up to 7 years imprisonment of life. No custom can create an offense as it is essentially deals with the civil right of the party, and no person can convicted of any other except of violation of law that cover in Article 20 of Indian Constitution Fundamental Right, Part 3. In force at the time of the commission of the act charged. Custom may be proved for the determination of the civil rights of the party, including their status, the establishment of which may be used for the purposes of the proving the ingredients of an offence, which under section 337 of the General Clause Act would mean an act or omission punishable by an law by way of fine or imprisonment. Article 20 of the Constitution granting protection in respect of conviction of offences provides that no person shall be convicted of any offence except for the violation of law in force at the time of the commission of that act charged as an offence. Law under Article 30, Clause 3 of the Indian Constitution means that law made by the legislature, including intra-virus statutory orders and the orders made in exercise of power conferred by the statutory rules. The expression custom and uses has been defined under Section 3, subsection A of the Act as Section 3A. The expression custom and uses signify any rules which, having been continuously and informally observed for a long time, has obtained the force of law among Hindus in any local area, tribes, community, group, or family, provided that the rule is certain and unreasonable or opposed to public policy, and provided further that in the case of a rule applicable only to a family, it has not been discontinued by the family. For custom to have the color of a rule or law, it is necessary for the party claiming it to plead and thereafter prove that the such custom is ancient, certain, and reasonable. Custom being custom is obliged to establish it by clear and unambiguous evidence. In Ramalakshmi Ammal versus Shivantha Perumal Setuyar, Mu A L A 5070 5085 585 86 is was held in it is of a sense of a special usages modifying the ordinary law succession that they should be ancient and invariable, and it is further essential that they should be established to be so by clear and ambiguous evidence. It is only by means of such evidence that courts can be assured for the of their existence and that they possess the conditions of antiquity and certainty certainty on which alone their legal title to recognition depends. The importance of the custom in relation to the applicability of the Act has been acknowledged by the legislature by incorporating Section 29, saving the validity of marriage solemnized prior to the commencement of the Act, which may otherwise be invalid after passing of the Act. Nothing in the Act can affect any right recognized by the custom or the conferred by any said enactment to obtain the dissolution of Hindu marriage. whether solemnized before or after the commencement of the act, even without the proof of the conditions precedent for the declaring the marriage invalid as incorporated in section 10 to 13 of in the Marriage Act. In this case, the appellant filed a complaint in the court of Chief Metropolitan Magistrate, New Delhi, stating therein that her marriage was solemnized with the respondent in the Delhi according to the Hindu rites and custom, alleging that the respondent has solemnized another marriage with accused. Second, the complaint pleaded. The accused one has not obtained any divorce through the court of law up to this date, and hence the action of accused one is illegal, contravenes, and the provision of the law laid down the under section 494 of Indian Penal Code. Now we are in the complaint. The appellant has referred to any illegal alleged custom having the force of law which prohibits the solemnization of second marriage by the respondent and the consequences thereof. It may be emphasized that the mere pleading of a custom stressing for monogamy by itself was not sufficient unless it was further pleaded that second marriage was fired by reason of its taking place during the life of such husband or wife. In order to prove the second marriage fired, the appellant was under the obligation to show the existence of a custom which made such marriage null, ineffectual, having no force to law or binding effect, incapable of being enforced in law or non-est. The fact the fact of second marriage being void is a sine qua non for a applicability of section 494 of IPC, Indian Penal Code. It is settled positions of law that for the sustaining the criminal liability and prosecution or the complainant is obliged to prove that the existence of the ingredient constituting the crime which are normally and usually defined by a statute. The appellant herself appears to be not clear in her stand in as much as in her statement in the court recorded on 24th October 1992. She has stated that I am a Hindu by religion. The complaint was dismissed the trial court holding. There is no mention any such custom in the complaint, nor is there evidence of such custom. In the absence of the pleading and the evidence, their reference to the book alone is not sufficient. The High Court void the judgment impugned in this appeal, held that in the absence of notification in terms of subsection 2 of section 2 subsection 2 of section 2 of the act, no case of prosecution for the offense of bigamy was made out of against the respondent because the alleged second marriage cannot be termed void either under the act or any alleged custom having the force of law. In view of the fact, parties admittedly belong to the scheduled tribe within the meaning of clause 25 of article 366 of the constitution as notified by the constitution scheduled tribe order 95T as amended by the scheduled caste and scheduled tribe order amendment act 63 of 1956, 108 of 70, 1970, 18 of 87, and 15 of 90, 99, 90, passed in terms of Article 344, 342, and in absence of the specific pleading evidence and proof of the alleged custom, making the second marriage void no offence under the section 494 of the Indian Penal Code can possibly be made out against the respondent. The trial magistrate and the Hindu court have rightly dismissed the complaint of the appellant. There is no merit in this appeal, which is accordingly dismissed. So guys, this is all about the case. I have read properly. I hope this video will help you to how to question answer from the case mates on the basis of uh, leading case. So we will next video will cover the next case, namely the Nagalingam versus Shivangami, citation 2001 of 7 edition, Supreme Court, page number 487. Okay, thank you so much for watching this video. I hope this video will help you to understand who is Hindu or who is not, and the applicability of the Hindu Marriage Act 1955 for whom, and also for punishment for the bigamy under the provision of 494 of the Indian Penal Code. There are the some provision, the article regarding the 2342 and so on. So guys, all you need to know about the special articles and section of the constitution and the sections of the Hindu Marriage Act. So thank you so much for watching this video. I hope this video will help you to understand the all things about the case. Thank you so much. Bye bye, take care, have a nice day.